Please be seated.
Good morning, everybody. Madam Registrar, could you open the proceedings, please?
Thank you, Mr. President, Your Lordships. Trial Chamber 3 of the International Criminal Tribunal for Rwanda, composed of Judge Dennis Byron presiding, Judge Bedao Gustav Kam, and Judge Wagner Johansson, is now sitting in open session today, Monday, the 22nd of June, 2009, the delivery of judgment in the matter of prosecutor Callixte, case ICTR-0-88. Thank you, President, Your Lordships.
Thank you, Madam Registrar. Could we have appearances, please?
Good morning, Your Lordships, and good morning to my colleagues on the defense side. Prosecutors appearing in person, and with me are the Chief of Prosecutions, Mr. Richard Karegeza, Senior Trial Attorney Christine Graham, Trial Attorney Usman Jame, and our case manager, Seamus Magan, as it pleases the court.
Thank you, Mr. Prosecutor.
Bonjour, Monsieur le Président.
Good morning, Mr. President, Your Honors. The defense bench is made up of my co-counsel, Antagise Yohan Sufi, legal assistant, and myself, lead counsel, Arthur Verken, for Callixte Kalimanzira.
Thank you, Mr. Verken. Today, the Chamber delivers its judgment in the case of the prosecutor versus Callixte Kalimanzira. A summary of the judgment will now be read out. It is to be understood that the written judgment, which will be distributed at the close of this hearing, is the only authoritative statement of the Chamber's findings and reasoning in the present case. The indictment charges Mr. Kalimanzira with 3 counts: genocide, or in the alternative, complicity in genocide, and direct public incitement to commit genocide. All of the alleged events on which these charges are based occurred from April through June 1994 in Butari Prefecture. Kalimanzira is a native of Butari Prefecture and was born in 1953. The prosecution alleges that from 6 April to 25 May 1994, he acted functionally as the Minister of the Interior in Faustin Munyazeza's absence. He is also alleged to have been a high-ranking member of the MRND party and to have acted as the master of ceremonies at the MRND Palace meeting on 19th April 1994, aimed at triggering killings of Tutsi in Butari Prefecture to parallel those already underway throughout the rest of the country. Kalimanzira, who was well-liked and highly respected by the local population, is accused of abusing his authority to instruct, encourage, and prompt the population of Butari Prefecture to kill their Tutsi neighbors. The defense contends that Kalimanzira was not a political man, but someone who worked to develop and empower his local community, Tutsi and Hutu alike, through the use of agriculture. He is presented as having discharged his duties as a civil servant with honor and integrity, and without ever harboring any anti-Tutsi sentiment in his life. Upon becoming Director de Cabinet of the Ministry of the Interior, Kalimanzira insists he was merely a technocrat without any political authority. Apart from a few specified occasions, he claims to have remained in Gitarama Prefecture throughout April and May 1994, and at home in Butariville throughout June. This is Kalimanzira's alibi in defense of most of the incidents alleged by the prosecution. Before turning to the facts of this case, the Chamber will discuss some preliminary matters. In its closing brief, the defense objects, among other things, to the vagueness of paragraph 15 of the indictment relating to the erection and supervision of roadblocks, and to the introduction of several events for which it claims it did not have sufficient notice, including, but not limited to Kalimanzira's participation in Butari Prefectural Security Council meetings and his presence at the inauguration of Eli Ndajiambaji. The Chamber has considered the defense's objections and agrees that paragraph 15 was impermissibly vague. In some instances, the Chamber has pro motu addressed possible lack of notice, even when no specific objection has been made by the defense, based on the organization and argumentation of the prosecution closing brief. In most instances, the Chamber has found that the defense was given clear, consistent, and timely notice of the material facts underpinning the charges at paragraphs 8, 15, and 27 of the indictment. The Chamber also considered that the cumulative effect of the defects cured did not prejudice Kalimanzira's ability to mount an adequate defense. These and other legal issues are discussed in greater detail in the written judgment. I now turn to the Chamber's findings. Kalimanzira denies the allegations at paragraph 2 of the indictment that he acted as Minister of the Interior in Munieza's absence, and that he was a prominent member of the MRND party, that he was closely affiliated with interim President Theodore Sindikubaba and Prime Minister Jean Kambanda, and that he held de jure or de facto authority over the people and officials of Butari Prefecture. The Chamber finds that while Kalimanzira was the officer in charge of the Ministry of the Interior in the minister's absence from 6th April to 25th May 1994, his delegated powers did not exceed those concerning the ministry's daily business. The political and initiative powers of the minister would have been exercised by persons higher up in the political establishment of the interim government. As to Kalimanzira's political affiliations, the Chamber finds that he was much more politically inclined than he admits. The evidence shows that he was indeed a prominent MRND member. As Director de Cabinet, Kalimanzira was the political advisor to the Minister of the Interior, who was also an MRND member. This suggests that Kalimanzira's MRND membership not only predates, but also contributed to his appointment. The evidence does not, however, show that Kalimanzira was a close ally of the interim president or prime minister. Rather, Kalimanzira's allegiance was to his minister, Faustin Munezeza, with whom he had a long-term working relationship, and who was most responsible for his rising career. The Chamber finds that Kalimanzira exercised a certain de jure authority while he was the officer in charge of the Ministry of the Interior, but his authority was limited to day-to-day affairs. To the extent that he held some de jure authority over prefectural, communal, and other local officials, it follows that he would also have held a certain level of de facto power over them. With respect to his influence in Butari Prefecture in particular, it is not disputed that Kalimanzira was well-liked, even loved, and highly respected. Kalimanzira's high standard and good reputation, not to mention the incrementally important governmental positions he held throughout his career, would undeniably imply an increased level of reverence from and influence over the population of Butari Prefecture. As previously mentioned, Kalimanzira offered an alibi defense. For reasons discussed more fully in the written judgment, the Chamber does not believe his alibi. Kalimanzira's work in Murambi, Gitarama does not preclude him from having traveled to Butari at other times than those he admitted to. And his assertion that he stayed in his home in Butariville throughout the month of June, except on a few specified occasions, is equally untenable. The Chamber recalls that its disbelief in Kalimanzira's alibi does not relieve the prosecution of its burden to prove its case beyond reasonable doubt. The prosecution accuses Kalimanzira of planning, ordering, instigating, committing, or otherwise aiding and abetting genocide at several locations throughout Butari Prefecture between April and July 1994. No evidence was led in relation to paragraph 11 of the indictment, accusing Kalimanzira of ordering killings and personally beating Tutsi to death at a roadblock near the Buzana River and at Rango, a few kilometers away. Similarly, no evidence was led in relation to paragraph 16, accusing Kalimanzira of distributing weapons in Kigembe commune and periodically replenishing a weapon stockpile at the Muganza commune office. These charges are therefore dismissed. With respect to Kalimanzira's alleged criminal conduct and the Zakindi roadblock, described at paragraphs 13 and 25, the Chamber finds AZH's uncorroborated evidence lacks sufficient reliability to sustain a conviction. The Chamber also finds AZH to be insufficiently reliable to lend corroboration to AZC's testimony on Kalimanzira's alleged instigation on the 5th of June 1994 in Muguza commune. With nothing else to lend credence or support to AZC's account, the Chamber finds that the prosecution has failed to prove the allegations at paragraphs 12 and 14 of the indictment beyond reasonable doubt. With respect to the MRND Palace meeting on 19th April, which Kalimanzira admits he attended, the Chamber finds no criminal responsibility ensues from his role as what could be described as being the master of ceremonies. In the presence of such high-level dignitaries as the interim Prime Minister and the interim President and Prime Minister, who were also natives of Butari, Kalimanzira's rank and authority were relatively insignificant. His failure to object to any portions of the allegedly inflammatory speeches could therefore not have substantially contributed to the commission of any of the crimes alleged to have resulted from those speeches. With respect to the archery training session held at the Muganza Commune football field in May 1994, pleaded at paragraph 17 of the indictment, the Chamber heard credible and largely reliable evidence from BCA, BBB, and BWI. However, the rally's purpose was to train the local population to handle weapons in order to assist the Rwandan armed forces at the approaching front if the RPF were to arrive in the area. The Chamber considers this to have been a legitimate civil defense exercise. As such, Kalimanzira's attendance and participation at this meeting cannot form the basis of a criminal conviction. In support of the allegations at paragraph 8 of the indictment that Kalimanzira visited Butare Prefecture on several occasions to incite the population to kill Tutsi and sensitize the population to the government's genocidal policy, the prosecution relies on AZM, BWI, FAC, AZT, BCA, and BBB, who testified to 5 separate events. Although the prosecution believes AZM's testimony that Kalimanzira attended several meetings of the Butare Prefectural Security Council in May 1994, there is insufficient evidence to conclude that instigation occurred at the Security Council meetings. And although the Chamber accepts that Tutsi were killed by the thousands in Butare, there is no evidence to link the Security Council meetings to those killings. BWI testified to another meeting at the Muganza football field, earlier than the one alleged at paragraph 17 of the indictment, where Kalimanzira allegedly instructed the population not to loot the property of Tutsi, but rather to exterminate them. The Chamber finds that the prosecution's failure to lead any evidence from BCA or BBB, who would also have attended or at least heard about this meeting, cast reasonable doubt on this allegation. FAC testified to a rally at the cemetery near Butare University, where Kalimanzira allegedly instructed some 2,000 persons present to continue searching for Tutsi in hiding and flush them out, which they did. Oddly, however, FAC said that 1 hour before this rally, he participated in a search for Tutsi in the nearby forest, where they found nobody alive. FAC did not explain why the search would be undertaken before, or who might have given instructions to do so. Defense witnesses Albert Barrick Winchie and Jean de Dieu Rutabana confirmed the occurrence of the forest search, but indicated that they were looking for hidden RPF combatants. They denied the occurrence of any rally before, during, or after the search. The Chamber considered FAC's testimony with caution and concludes, without corroboration, it lacks sufficient reliability to support a conviction. AZT accused Kalimanzira of instigating the audience at a public rally in the Butare sector to keep searching for Tutsi in hiding. He admits participating in killings which followed. As an accomplice, his evidence was viewed with caution. The defense called 3 witnesses who were also present at the same meeting, but who emphatically deny Kalimanzira's presence there and assert that the meeting's content was limited to security issues and calls for killings to stop. The Chamber considers that the credible and consistent evidence adduced from defense witnesses casts reasonable doubt on AZT's uncorroborated account. BCA and BBB testified that Kalimanzira was present at Eli Ndiambaje's inauguration ceremony in June 1994, where the new burgomaster of Muganza commune admonished those in attendance for continuing to hate Tutsi, using a metaphor of sweeping the dirt out of their homes. This led to the killings of Tutsi women, elderly, and children who had hitherto survived by being hidden. The Chamber places little weight on the defense's implication that simply because no defense witnesses saw Kalimanzira, he could not have been there. The Chamber finds that Kalimanzira's failure to reject Ndiabaje's inflammatory remarks amounted to an official sanction and tacit approval thereof. In this way, Kalimanzira aided and abetted the killings of Tutsi that followed. To prove the allegations in paragraph 15 of the indictment, that Kalimanzira called for the erection of roadblocks and supervised the operations to kill Tutsi, the prosecution relies primarily on the evidence of BDJ, AZH, BXK, and BXG. The Chamber finds that BXG's evidence on Kalimanzira's behavior at Mukabuga roadblock is irrelevant in relation to this charge. For the same reasons discussed in relation to his allegations at the Zakindi roadblock and Mugaza commune office, AZH's uncorroborated testimony that Kalimanzira ordered the erection of the roadblock at Kabanga Seliul to prevent Tutsi from fleeing the area is insufficiently reliable to sustain a conviction. The Chamber believes BDJ's testimony, supported by Prosecution Exhibit 54, that on 10th June 1994, Kalimanzira attended a meeting at the Endora Commune office, where he expressed anger that he had not seen roadblocks, thereby encouraging and instigating their erection and maintenance. However, there was no evidence regarding which roadblocks were erected upon Kalimanzira's instructions, or more notably, that any killings resulted from Kalimanzira's order at this late stage of the genocide. The Chamber finds that the prosecution has not proven beyond reasonable doubt that Kalimanzira's instructions substantially contributed to the commission of genocide. BXK's evidence about the roadblock on Butari-Gisagara Road was credible and reliable. He testified that Kalimanzira stopped there around 22nd April 1994, asked the men manning the roadblock why they had no weapons, and why they had instructed passing Tutsi to sit there instead of killing them. Kalimanzira then provided one of the men with a firearm, which was subsequently used to kill some of those very Tutsi at the nearby latrine pit. By these actions, Kalimanzira both instigated and aided and abetted the persons manning the roadblock to kill those Tutsi. The allegations at paragraphs 9 and 10 of the indictment, as well as the evidence adduced at trial, may be deconstructed into three categories of events. 1, sending Tutsi to Kibuye Hill. 2, killings at Kibuye Hill. And 3, supervising and discussing further killings at Kibuye Hill. The prosecution led evidence from several witnesses, as did the defense. The fact that several thousands of Tutsi were massacred at Kibuye Hill is not in dispute. Both the defense and the prosecution led evidence from survivors of these horrors. The defense relied primarily on Kalimanzira's alibi defense, supported by defense witness Mark Sinio Bayo, which the Chamber does not believe. The defense also relied on its witnesses, whose evidence was largely limited to asserting that they did not see Kalimanzira there. The prosecution witnesses, however, gave abundant and compelling evidence that he was. BWO, BCF, BDC, and BBO all testified to having seen Kalimanzira at Kibuyo Hill on or around Saturday, 23rd April 1994. BXJ witnessed Kalimanzira at a nearby roadblock earlier that day. BWO, BCF, BDC, and BXG are survivors of the attacks at Kibuyo Hill. BBO participated in the attacks. The Chamber found that BBO's testimony could not be relied upon where it was uncorroborated. BWK's evidence, along with BDC and BCF's, proved beyond a reasonable doubt that on 23rd April 1994, Kalimanzira personally encouraged Tutsi civilians to take refuge at Kibuyo Hill, promising them protection. He did so both tacitly at the Gisagara marketplace and expressly on the Kibuye-Gisagara Road. Defense witnesses AM14 and FCS failed to cast any doubt on the prosecution evidence in this regard. BWO and FCS's combined evidence supports the conclusion that the expulsion of Tutsi refugees from the Gisagara marketplace to Kibuyo Hill took place in multiple stages. BDC, BCF, and BWO gave credible and reliable evidence that Kalimanzira also came to Kibuyo Hill. There he witnessed the massive gathering of Tutsi refugees and brought armed reinforcements with him. BXG's account of Kalimanzira's behavior earlier, the same day, shows that he not only knew the Tutsi would be attacked and killed, but that he intended that this to be so. The defense led evidence from 3 survivors, FCS, AK-11, and ACB-6, and 4 attackers, Indiamu Gabi, NGB, Zabakarina, and Zabimana, to shed doubt on Kalimanzira's participation in the killings at Kibuyo Hill. All of them stated that they did not see Kalimanzira there or ever heard of his involvement. Having reviewed the defense evidence carefully, the Chamber finds it does nothing to contradict the prosecution case. In fact, in many ways it supports it, thereby providing a broader historical record of the killings at Kibuyo Hill. The body of evidence reveals that there were thousands upon thousands of refugees suffering battle and massacre from an indeterminate number of attackers over a large landscape and time span. No witness alone could amply describe everything that transpired or identify everyone who was present. BDK was the only prosecution witness to testify to allegations at paragraph 10 of the indictment, whereby Kalimanzira and other local officials met at Fidel Uize's house to discuss further action to make up for their failure to eliminate the overwhelming number of Tutsis who had gathered at Kibuyo Hill. Defense witness AX88 directly contradicted BDK's evidence. Though the Chamber does not believe AX88's testimony, it is not entirely convinced by BDK's account either, and considers her sole evidence to be insufficiently reliable. The Chamber concludes that on 23rd April 1994, Kalimanzira came to Kabuya Hill with soldiers and policemen. The Tutsi refugees had successfully repelled attacks with sticks and stones until that day, but they could not resist bullets. With significantly more civilian attackers on the ground, the Saturday attack proved successful, and the Tutsi refugees were killed in the thousands, resulting in an enormous human tragedy. Kalimanzira's role in luring the Tutsi to Kabuya Hill and his subsequent assistance in providing armed reinforcements substantially contributed to the overall attack. The Chamber finds Kalimanzira guilty beyond reasonable doubt for aiding and abetting genocide at Kabuya Hill. Having found Kalimanzira guilty of genocide under count 1 of the indictment, the Chamber dismisses count 2, complicity in genocide. Under count 3, the prosecution accuses Kalimanzira of committing several acts of direct and public incitement to commit genocide. No evidence was led in relation to paragraph 19 of the indictment, accusing Kalimanzira of inciting the population in late March 1994 at the Gisagara marketplace to arm themselves and prepare to fight the enemy, encouraging those who could manufacture traditional weapons to do so, and promising to supply the people with firearms. This charge is therefore dismissed. In relation to paragraph 20 of the indictment, accusing Kalimanzira of incitement at the Burundian refugee camp in Kenagi, Seoul, the Chamber finds that BBO's uncorroborated evidence is not sufficiently reliable to sustain a conviction. The Chamber does not believe Kalimanzira's alibi that he stayed at home in the days following the death of the president. For the same reasons, however, it doubts that Kalimanzira went to Kenagi camp. In the absence of additional information or explanation, it would seem likely that at such a critical time, and in the absence of his minister, Kalimanzira would have had more important matters to attend to in Kigali. Paragraph 21 of the indictment alleges Kalimanzira distributed a rifle at the Jaguar roadblock in mid-April 1994 and incited the persons man in it to use the weapon to kill Tutsis. BWL, BCN, and BCK gave corroborating, credible, and reliable evidence to support this allegation. Defense witness Neon Saba and Harind Wali admitted to manning the roadblock, but denied Kalimanzira's presence there at the time alleged. Both witnesses live in exile and have an interest in denying that any criminal acts occurred at the Jaguar roadblock. They failed to cast doubt on the prosecution evidence. The Chamber finds that Kalimanzira's incitement to kill Tutsi was clear, direct, and made in a public place, the roadblock, to an indeterminate group of people, those man in it. As such, Kalimanzira is guilty of committing direct and public incitement to commit genocide at the Jaguar roadblock. BBB and BXH were called in support of the allegation at paragraph 22 of the indictment in relation to the incitement at the Kajinama roadblock. The defense claims that AM05, AM02, and AM29's evidence that they did not hear of the incident to which BBB and BXH testified should be believed, because in a community as small as Kajinama Seoul, even the passing of a car was a significant event, and the passage of Kalimanzira, a former superprefect, was something that everyone would have heard about. These arguments are not persuasive. After careful consideration, the Chamber concludes that BBB is a reliable witness. His testimony was corroborated by EXH, whom the Chamber also believes. The Chamber therefore finds that in late April 1994, Kalimanzira reprimanded and then abducted a man at the Kajinama roadblock for being unarmed, and exhorted those manning the roadblock to carry arms in order to defend themselves against the enemy who might pass through. Kalimanzira was understood to be calling for the killing of Tutsis, and the Chamber finds that he intended to be understood as such. The incitement was disseminated in a public place, the roadblock, to an indeterminate group of people, those manning it, and anyone else watching or listening. As such, the Chamber finds Kalimanzira guilty beyond reasonable doubt for committing direct and public incitement to commit genocide at the Kajinama roadblock. BCZ was the prosecution's sole witness to testify to the charges at paragraph 23 of the indictment relating to Kalimanzira's alleged incitement at the Niabisagara football field. Because he's an accomplice, the Chamber considered his testimony with caution. After careful consideration, the Chamber found that no motive or incentive to lie could be demonstrated. The defense called 4 witnesses who testified to another meeting at Niabisagara football field and asserted that Kalimanzira was not there. Their evidence supports the inference that there was more than one meeting at Kibaya commune at the time. It therefore does nothing to rebut BCZ's evidence, which the Chamber considered to be credible and reliable. The Chamber therefore finds that in late May or early June 1994, Kalimanzira attended a public meeting at the Niabisagara football field, where he thanked the audience for their efforts at getting rid of the enemy, but warned them not to grow complacent, to remain armed at all times, and exhorted the crowd to keep searching for enemies hidden in the bush or in other persons' homes, which they did. He also instructed them to destroy the homes of dead Tutsi and plant trees in their place, which they did. Kalimanzira's call for further elimination of Tutsi in hiding was direct, leading to immediate and commensurate action. It was disseminated in a public place to a large public audience. The Chamber therefore finds Kalimanzira guilty beyond reasonable doubt of committing direct and public incitement to commit genocide at the Niabisagara football field. BCZ also testified to the allegations in paragraph 24 relating to Kalimanzira's alleged incitement at the Ramiko Primary School. Though his testimony was largely uncorroborated, other witnesses, defense and prosecution alike, supported it in several particulars. The Chamber believes that a group of persons, including BCZ, congregated to decide how to share and distribute the property of dead Tutsi. The Chamber also believes that the meeting described by BCZ took place at the Ramiko Primary School. However, the prosecution failed to prove the public nature of this meeting beyond reasonable doubt. The Chamber therefore finds that Kalimanzira's presence and words to the crisis committee at the Ramiko Primary School do not amount to direct and public incitement to commit genocide. The prosecution relies mainly on BDE's evidence, as supported by BCZ, to prove the allegations in paragraph 26 of the indictment that Kalimanzira encouraged people manning the Nyarusanga roadblock in mid-1994 to continue checking everyone's identity cards and search for the Tutsi enemy. BDE was the Hutu motorcyclist Kalimanzira allegedly criticized and punished for not carrying a weapon with which to kill Tutsi. When Kalimanzira was at Ramika Primary School, BCZ saw BDE and his motorcycle in Kalimanzira's vehicle parked outside. The defense called AM52, who is BDE's brother, and KUW to refute different aspects of BDE's allegations. The chamber found that neither defense witness undermined BDE's account, which was credible and reliable. However, the chamber does not find that this incident amounts to direct and public incitement to commit genocide. In order to be criminal, the incitement must be both direct and public. And the chamber finds that the criterion is not met, that the first criterion is not met in this instance. There is sufficient evidence to conclude that BDE understood Kalimanzira's actions and speech to be a call for him to kill Tutsi. And the chamber cannot infer that those manning the roadblock would have understood it as such. No conviction may be entered here. Finally, in relation to paragraph 27 of the indictment, the prosecution relies on AZT, BCK, BDJ, BDK, and AZC. While the chamber believes AZT saw Kalimanzira slap an unarmed man at the roadblock in Nyarusanga cellule, there is insufficient evidence to show that this amounted to direct and public incitement to commit genocide. In a similar vein, the chamber does not consider BCK's credible evidence that Kalimanzira beat witness Harindin Twali with a club for failing to carry a weapon to amount to proof beyond reasonable doubt that Kalimanzira committed direct and public incitement to commit genocide. The chamber believed BDJ's testimony that in mid-1994, Kalimanzira rebuked two persons at a roadblock in Kibuyo Cellule for failing to carry arms and told them that unarmed persons were to be considered the enemy. However, in light of the statement's ambiguity, which seemed individualized to the two recipients only, the chamber is not satisfied that direct and public elements were proven beyond reasonable doubt. BDK's evidence, which the chamber accepts, was that at the end of May 1994, at a public meeting in Gisagara Marketplace, Kalimanzira criticized those in attendance for being unarmed and told them that they had not completely defeated the enemy. He rewarded a man who was carrying a club with spikes and an iron bar from a wrecked car. Kalimanzira went on to incite the crowd to kill young Tutsi girls who had hitherto been spared by being forced into marriages. BDK understood that by the enemy, Kalimanzira meant the Tutsi. The chamber finds that this also would have been the understanding of the crowd at the meeting. This finding is supported by BDK's evidence that although there had been no attacks for a week before the meeting, they resumed afterwards, and she named several people who were killed. The chamber finds that the only reasonable conclusion that can be drawn from this evidence is that Kalimanzira intended to incite the crowd to carry weapons in order to kill Tutsi civilians. Consequently, The Chamber finds Kalimanzira guilty beyond a reasonable doubt for committing direct and public incitement to commit genocide at the Gisagara marketplace at the end of May. The Chamber has found direct and circumstantial evidence that in committing his crimes, Kalimanzira held the requisite specific intent characterizing the crime of genocide, which is the intent to destroy, in whole or in part, the Tutsi group as such. Would Mr. Kalimanzira please stand so the court can now state its verdict? For the reasons set out in the judgment, having considered all the evidence and arguments, the trial chamber finds unanimously in respect of Callixte Kalimanzira as follows. Count 1, guilty of genocide. Count 2, dismissed. Count 3, guilty of direct and public incitement to commit genocide. The chamber now determines the appropriate sentence. The prosecution submits that Kalimanzira should be sentenced to life imprisonment. The defense has made no submissions on sentencing. At this tribunal, a life sentence is generally reserved for those who planned or ordered atrocities and those who participate in the crimes with particular zeal or sadism. Offenders receiving the most severe sentences also tend to be senior authorities. In Kalimanzira's case, the chamber takes into consideration his prominence and high standing in Butari society as a former superfect, and the fact that he was one of only 3 people from his area and generation to have received a university education. He was loved and appreciated for his efforts at empowering his community by agriculturally developing his native region. The influence he derived from this and his important status within the Ministry of the Interior made it likely that others would follow his example, which is an aggravating factor. Most significantly, by encouraging Tutsi refugees to gather at Kibuye Hill, where he knew they would be killed in thousands, he abused the public's trust that he, like other officials, would protect them. However, the chamber notes that Kalimanzira's actions did not evince any particular zeal or sadism. He did not personally kill anyone and only remained at the sites for brief periods. As far as mitigating circumstances, the chamber finds there are few. Kalimanzira voluntarily surrendered to the tribunal and lived openly prior to his arrest. For much of his life prior to the genocide, Kalimanzira was engaged in the public service of his country. The defense tried to show that he never harbored anti-Tutsi sentiment before the genocide, but such evidence can in no way exonerate Kalimanzira for his crimes. In the chamber's view, after weighing the gravity of the crimes and Kalimanzira's individual circumstances, limited mitigation is warranted. The chamber decides to impose a single sentence. Considering all the relevant circumstances, the chamber sentences Callixte Kalimanzira to 30 years imprisonment. Kalimanzira shall receive credit for his time served since he was arrested in Nairobi on 8th November 2005. This amounts to 3 years, 7 months, and 14 days. In accordance with Rules 102A and 103, Kalimanzira shall remain in the custody of the tribunal pending transfer to the state, where he will serve his sentence. Thank you. You may sit. Are there any matters arising? If there are no matters arising, the court will then take its adjournment. The court adjourns.
All rise.